Good morning. The legislature is back in session. Let's start with the bill. Vice Speaker, you're recognized. There are some amendments if you would rather that we start with the amendments.
Thank you, Mr. Speaker. I want to thank the body for the recess yesterday so that we could confer the Attorney General and the presiding judge as to some of the language in this bill that had been questioned. I think there were good questions, and there are some clarifications that we will propose to be made, and so I hope that that will clear up some of the issues that were raised yesterday. I think the floor amendments are being passed. If I could make some of these amendments.
I understand Senator Torres also has a couple of amendments, so if you would rather let her do, or do you want to go first?
That's fine if you will allow me to speak again before.
Yes, of course.
I just thought it would make things faster instead of having a debate on these certain issues. We've also discussed her amendments of the AG, and they are very helpful also. So yes, we need all those, some of those also. So, but I think mine are also passed out. If we could just dispose of those, Mr. Speaker.
All right, Dar.
One of these is a floor amendment that was raised on a question by Senator Espaldon regarding the definition of alcohol. It's on page 29 of the bill, line 15.
Okay, if it be okay, let's take Senator Torres's. They seem very simple, and I'm hoping that by the time we get back to you, Senator Espaldon will be here so that he will participate in that discussion on his amendment. Okay? Senator Torres, let's get yours out of the way, and then she can have the...
Zeus Masi, Mr. Speaker, and good morning, colleagues. I'd like to move to make an amendment on page 1, line 13 to 14 of the bill. And I spoke on this yesterday about the authority to establish courts, and I had referred to the Organic Act, specifically section 1424A2, which provides that the Supreme Court of Guam may, by rules of such court, create divisions of the Superior Court of Guam and other local courts of Guam. And although the argument and the debate can go back and forth, and perhaps it's ambiguous about who has authority, I do believe that the Organic Act is clear about the Supreme Court's authority, and that it is no harm and actually is more consistent to change the language as such. So on page 1, lines 13 to 14, I propose that D be reworded to state DWI Treatment Court, the Supreme Court of Guam may establish a driving while impaired treatment court, DWI court, period.
All right, everyone has a copy of that amendment. Anyone wish to be heard on the amendment? Vice Speaker?
Thank you, Mr. Speaker. There has been some inconsistencies as to requests for, whether to put the Supreme Court or the Judicial Council, and I acknowledge the authority of the Supreme Court to do this if they desire to do this, and that I don't think this bill takes anything away from them. But this also, I believe, is consistent with the Organic Act in that it just one second. in the Organic Act says the judicial authority of Guam shall be vested, and it goes on, but then the relevant subsection says the courts of record for Guam shall be the District Court of Guam, the Supreme Court of Guam, the Superior Court of Guam, except the Traffic and Small Claims Division of the Superior Court of Guam, and any other local courts or divisions of local courts that the Supreme Court shall designate. And in subsection 1, it says, the judicial authority of Guam shall be vested in a court established by Congress designated as the District Court of Guam, and a judicial branch of Guam, which branch shall constitute a unified judicial system and include an appellate court designated as the Supreme Court of Guam, a trial court designated as the Superior Court of Guam, and such other lower local courts as may have been or shall hereafter be established by the laws of Guam. So it's our Council's advice that this is also consistent with the authority in the Organic Act to establish courts by laws of Guam. And I just also wanted to point out that in Title VII, Section 2101, there were several courts established by the Guam Legislature, and it says the courts of justice of Guam shall consist of the Supreme Court of Guam and the Superior Court of Guam. And then it talks about the authority, and it says the Supreme Court may, by rules of court, create such divisions of the Supreme and Superior Courts as may be desirable, and may designate which of the divisions of the Superior Court are to be courts of record, and which shall be courts not of record, provided, however, that for such divisions of the Superior Court, and this is where the legislature mandated which courts were going to be established, provided, however, that for such divisions of the Superior Court shall continue, one being the Traffic Division, not a court of record, one being the Small Claims Division, not a court of record, a third being the Family Division, a court of record, and the fourth being the Drug Court, a court of record. And then there was the establishment of the Guam Veterans Court, also pursuant to public law. And this was done in a prior Guam legislature, Guam Veterans Treatment Court. It says the Judicial Council of the Judiciary of Guam may establish through a duly adopted resolution, and this is a may, just the same as this bill, a Guam Veterans Treatment Court program in accordance with the provisions contained in this act. This is the same language that was used recently in the reentry bill. That was also a may, and so that's why I just wanted to make the establishment of this court, if we are going to do it by legislature, to be consistent with those languages. Thank you, Mr. Speaker. So I would object to that amendment, that one. Thank you.
Thank you. On the amendment, Senator Nicholas.
Mr. Speaker, I just wanted to put on the record, I made a motion yesterday that I withdrew to move this bill back to committee for work. I now have 7 amendments on my desk for this bill. We're on the first one. I may have 3 more that I would need to do. You know, in the interest of getting these things done and vetting them with everyone's input, you know, we can either do this on the floor or we can do this in committee.
Thank you. On the amendment, any other senator? Senator Torres.
Mr. Speaker, I just want to clarify, in other words, what I'm attempting to do. The language right now reads that the Judicial Council of the Judiciary of Guam may establish, through a duly adopted resolution, a DWI treatment court. The reason that I believe I would like to amend this is, in looking at a prior resolution by the Judicial Council, it is clear in the resolution that, as I mentioned before, pursuant to the Organic Act, the Supreme Court has the authority to establish courts. The Judicial Council is authorized pursuant to statute to adopt policy for the operations of the court. In past practices, as I'm aware, and in looking at a resolution, JC 18006, which was passed in March of 2018, the way that I understand the process is the Judicial Council recommends by resolution to the Supreme Court that it approve. And the resolution that I'm referring to had to do with the Adult Reentry Court Program. So it's not that I'm saying that there's only one way. Clearly, we can pass laws to set up courts, and I'm not disputing that. But I'm just stating that I propose, and it is my desire, that lines 13 to 15 be amended so that the authority to stand up this court is not by the Judicial Council. Simply because the way I understand it, the Judicial Council adopts resolutions that they then submit to the Supreme Court with their recommendation. But ultimately, it is the Supreme Court that blesses it, not the Judicial Council. So that's all I want to make clear, and it's, well, on the basis that I'm really just referring to what is clear in the Organic Act, that is the basis. But generally, it's also whatever action of the Judicial Council is a recommendation to the Supreme Court, and it is approved by the Supreme Court. Thank you, Mr. Speaker.
Thank you. There's been an objection to the amendment. All those in favor of anybody else wish to be heard? If not, it's a fairly simple amendment. All those in favor of the amendment that's been objected to, please indicate by raising your hand. Amendment passes. Senator Torres, you're recognized.
Mr. Speaker, a very simple amendment which may have just been an oversight. On page 30, line 3, I would like to insert the word of alcohol so that line 3 reads, a motor vehicle under the influence of alcohol, comma, or the ingestion. And I believe in the first submission of the bill that word was included, and then it inadvertently perhaps was excluded in the substituted version.
On that amendment, was that intentional exclusion, Madam Vice Speaker, from the committee?
I was going to speak on the amendment if
Please.
No, we agree with this amendment. I think it was a typo, and with further consultation with the Attorney General, I would also suggest that we add in the words, sorry.
Let's just take this amendment that you're not objecting to, and we'll get it approved, and then you can make your further amendment later. Senator Estevez on the amendment.
Mr. Speaker, just to be clear, I know the mover of the amendment stated that it was on line 3, but at least in my version of the bill and reading the text, it should be line 4.
Okay. Please. The clerks will note that. Okay. So just for the insertion of the word alcohol, is there any objection? Anybody else? If not, amendment passes. Your next amendment, Senator Torres.
On page 32, Mr. Speaker, again, just minor typos on line 12. I believe that it should read through E and not F. So my amendment would be to change on line 12 the letter F that's in parentheses to E. Because it references subsections prior, so that would be A to E.
Any objection? Hearing none. Motion passes. Do you have any other amendments?
Yes. Again, on page 32, line 18, minor typo, which is a misspelling of the word nolo contendere. It says nolo contendere, it's nolo contendere, so just noting that technical correction. And then, Mr. Speaker, my last amendment is to page 33, line 2. It was noted in prior discussions that, that perhaps that sentence is incomplete or was misstated, so I propose an amendment to clarify it, to read on line 2, a person convicted of a first violation of driving while impaired is guilty of a misdemeanor and shall be sentenced as follows.
On the amendment?
Yes, we have no objection to this amendment, Mr. Speaker. This is a good amendment. Thank you.
Any other senator wish to be heard on it? There being no objection, amendment passes. Any other senator wish to be heard on the main motion before? Oh, go ahead, Vice Speaker. You have a series of amendments.
Mr. Speaker, on the same page that we were just on, page 33, and that same section 92104, I just want to change the word "and" to "or" on subsection D. It's not been passed out. It's on page 33, line 1. It's just changing the word "and" to "or." 33. I'm sorry, line. Line 12, where it says that he or she has successfully completed a drug and alcohol treatment, should be drug or alcohol treatment program. So it's changing the word "and" to "or" on line 12.
Does everybody see that on line 12? Is there an objection? Anyone wish to be heard on it? If not, motion passes.
Thank you, Mr. Speaker. Okay, now these are the amendments that I have passed out, and one is, again, a typo on page 38, line 4. It's the numbers and the letters or the words don't match, so it's to make the number 3,000 match with the word, and the word should be 3,000. So on line 13, on page 38, sorry, the floor amendment says the wrong line number, but it should be line 13, no, sorry. Gosh, wait, it's line mandatory 3,000. Line 13, yeah, that's correct, line 13. B, subsection B, where it says a mandatory fine of $2,500, it should say 3,000, and that would make it match with the numeral in the parentheses. So the word $2,500 should change to $3,000.
Does everybody see that amendment? Any objection? If not, amendment passes.
Thank you very much,
Yeah.
Mr. Speaker. One more is on page 29, line 15. It's the definition of alcohol reads currently, and alcohol means a colorless, volatile, flammable liquid synthesized or obtained by fermentation of sugars and starches and widely used, and it goes on. But this colorless was a point that was raised yesterday by one of my colleagues, and I think, well, the authors of the bill who have helped me to write this, alcohol means a volatile, we can remove the word colorless. So that's this floor amendment has been passed out, and it is to delete the word colorless, and so that it would, and add the word "or," so that it will now read alcohol means a volatile or flammable liquid, and the rest of the definition stays intact.
Is everybody clear with that amendment? Everyone understand what that amendment is and are clear with it? Any objection? Any objection? If not, amendment passes.
Thank you, Mr. Speaker. Now, the next two amendments, they kind of go hand in hand, but these are being made thanks to the vagueness that was pointed out yesterday during our discussion. And so on section 92101F, this is on page 30 of the bill, there's a definition of driving while impaired. So this definition, because this is what they will be charged with, is driving while impaired, is crucial, of course, to this bill. And I would like to make the amendment as shown, so it would be to add the words, in addition to driving, operating or in physical control of a motor vehicle, and under the influence of alcohol or any controlled substance. And then the rest of the definition kicks in, and in this definition you will note it says, it clarifies that when as a result of these things, or the mental or physical or mental abilities are impaired to such a degree that he or she is no longer able to drive.
So for all the colleagues that are following, it's the amendment to F?
That's correct. 92101F,
Is everybody clear?
page 30.
It's on, you've received all. Senator Estevez, did you wish to be heard?
Thank you, Mr. Speaker. As the bill currently reads on section F, it already, in regards to the amendment, it already covers ingestion or administration of controlled substances. But then at the end of that, when as a result his physical or mental abilities are impaired to such a degree that they can't operate the vehicle safely. What I do want to contest is the additional verbiage of or any controlled substance versus the term or any substance, which still as a result would result in the physical or mental inability or reduced capability of operating a motor vehicle. And that's only because there are medications out there, Mr. Speaker, that are not under the controlled substance list that can affect the operating of motor vehicles. And when patients are prescribed these medications, they're notified and they're instructed by their doctor whether or not they can safely operate a motor vehicle. And I just believe that if we want this bill to be all-inclusive to provide for safer streets, we should account for that. And if we were to remove the word controlled substances on the amendment, it would cover both controlled substances as already prescribed in the current language of the bill, and would also be inclusive of prescription medications not under the controlled substance listing that would still impair driving.
Thank you. Any other senator wish to be heard on the amendment to F? He was just saying that he has concerns about your amendment, and so are you offering to strike control?
Yes, Mr. Speaker, I'd like to offer an amendment to the amendment, and that's on the Terlahi amendment. Excuse me. On line 3 of the amendment, to read alcohol or any substance, and to strike controlled from that line.
Is everybody clear with the proposed amendment by Senator Estevez? That on the Terlahi amendment, he's moving to strike the word controlled in the third line. So the mean reads any substance. Senator Nicholas, I see you grimacing there. Is it my MSG? Senator, Vice Speaker, you're recognized.
Yeah, I just want to point out that I forgot to mention that the word alcohol was already added by a previous amendment by my colleague, and So that's already in there. But also, if you look at this section 92102 on pages 31 and 32, it does talk about other substances, and it's in subsection E. It says, having inhaled, ingested, applied, or otherwise used any chemical, poison, or organic solvent, or any compound or combination of these, when as a result his physical or mental abilities are impaired, and it goes on. So that covers other substances, but I'm not sure the effect of this amendment, Mr. Speaker, to remove the word. I guess, I mean, it looks like it would broaden it beyond controlled substances and beyond substances that were listed in subsection E. If I could have a 1-minute recess, Mr. Speaker.
We'll take a
Okay, all right. Mr. Speaker, I guess I would just object to that amendment, and I think we just need to leave the word controlled in there and hope that the other subsection would capture the other things sufficiently. Thank you.
Senator Esteves has made a motion to strike the word controlled. The Vice Speaker has objected to the amendment. Any senator wish to be heard on the amendment by Senator Esteves? It's been objected to. Senator Torres.
If I may, if the proffer of the amendment to the amendment may yield, in striking controlled, are you referring to things such as medication that may cause drowsiness or something like that? It is, okay. Because in that regard, that is a very practical amendment, I would think.
Senator Nicholas.
Thank you, Mr. Speaker. I was refraining. I'm hoping that, anyway, I think we need to be very careful. Like, let's say, for example, someone's diabetic and they had too much sugar, and their driving became impaired technically by making it any substance. They would be, they'd be considered driving while intoxicated or driving while under the influence. So I think keeping it controlled is necessary. It makes it very clear that, there was a certain substance that was very clearly warned or labeled that, using this inappropriately could result in you being unable to operate a vehicle, or if that's a prescription, or, a Schedule I controlled substance, an illegal drug. So I think leaving the controlled aspect in there is necessary. Otherwise, we're opening the door. Somebody could have overeaten and indigestion could have caused them to swerve. This is serious, Mr. Speaker, in terms of the implications of making it too broad. So I support the objection to the amendment.
Any other senator wish to be heard on the Esteves amendment? On the Esteves amendment, there's been did you wish to close?
Thank you, Mr. Speaker. The reason for this, and as brought up by a previous colleague, this should be inclusive of medication that makes somebody drowsy. Those with medical impairments that affect their driving are just as much of a risk as somebody who intentionally gets on the road when they're impaired. And people with these types of conditions should be very knowledgeable and are educated by the doctor on how they should be managing their treatments, how they should be managing their medication, and before they get, driving is a privilege, Mr. Speaker, and before anybody gets behind the wheel, they should make sure that they're able to operate that vehicle safely, whether it's a medical condition, whether it's lack of sleep, or whether they've taken any type of substance. If we're trying to promote responsible operation of motor vehicles, then we need to stay consistent. The concern I had with not implementing this section into subitem F, this is the definition for DWI. So if we don't include, even though it's reflected on page 32, item E, if we don't put it here, then driving under the influence of a muscle relaxer or anything that might make them drowsy, or misuse of an over-the-counter medication, such as Robitussin, or any number of combination of medications and chemicals, it's not in the definition of driving while under impaired or driving while impaired. At least I don't believe the definition is strong enough. So if somebody does either intentionally or unintentionally operate a motor vehicle, I don't believe that this captures that individual as as breaking the law in terms of unsafely operating a motor vehicle, whether intentional or unintentional. I think the results that we want are the same. At this time, Mr. Speaker, after conferring with legal counsel, I believe there is maybe some additional verbiage to clarify what exactly we're doing this in the amendment, and the amendment to the amendment, and I humbly ask that we just take a short recess while we perhaps come to a consensus and address that language.
I'll allow for a very short recess. If council has been, please. Legislature's back in order.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. While I do still believe that taking a substance that impairs driving is a danger to to those and others, other motorists and other pedestrians on the roadways. At this time, Mr. Speaker, I will withdraw the amendment to the amendment for the sake of understanding that such an amendment may be too substantive for this bill in its current form, and will probably reserve and take the opportunity to work with colleagues to try to reinforce either this law, if passed, or another law to try to encapsulate individuals that take substances outside of the scope of this law that impair driving and make the roads less safe. So at this time, I do remove my amendment to the amendment.
Thank you, Senator. So we're left with the Terlahi amendment. Any other senator wish to be heard on the Terlahi amendment? Any objection to the Terlahi amendment? If not, passes. Madam Vice Speaker, you have one more amendment that's been circulated.
Thank you very much, Mr. Speaker, and thank you to my colleagues. One more amendment that's been passed out is to Section 92102, driving while impaired. And this is the statute that says what's unlawful. So I would take out the words under subsections A and B that currently show while under the influence of alcohol and while under the influence of a controlled substance, and instead make those to read while driving impaired. And then that would refer back to the definition that we just worked on. And so it should cover those. And if you will notice that the subsection then continues on with it's unlawful to drive while impaired which would go back to that definition, meaning under the influence of alcohol or a controlled substance with other factors, or the new B would be with a 0.08% if you're an adult, a 0.04% if you're under the age of 21, having inhaled, ingested any other chemical poison, then they go on with that in subsection D. So those are those other things that they might also charge you with for driving while impaired, and I'd like to add the word or right before the last subsection. So, or having any combination of these.
Okay, colleagues, we've all been given a revised 90102. Has everybody had an opportunity to review it? It's the amendment on page 31. There's a strike through on the number 3, and it has a 20. It's been circulated. Please make sure.
Oh.
The third Terlahi amendment. It's fairly comprehensive, so that's why I wanted it circulated so everybody sees it.
It's the long one, the long one,
Okay? Does everybody have a copy of the amendment? Any senator wish to be heard on this amendment? Senator San Augustine, I see you rising. You're recognized.
Mr. Speaker, I just have to ask the author of the bill that as we put it, to change the while driving impaired, wouldn't it be appropriate to write the section of page 31, 9101, section F or whatever, just to refer to that, because otherwise I'm looking for another page when it should have just referred to that. That's the only thing I wanted to mention.
Madam Vice Speaker, do you yield?
Yes, I would yield, and actually, that's a good idea. We could say as defined by 92101F.
And where would that be?
Just after the words, in subsection A, while driving impaired,
Let's take a short recess. Okay. So does everybody understand that? The suggestion by, suggested amendment by Senator San Augustine is to, after the word impaired, right, as defined in 92101F,
I would just ask that legal also be allowed to fluctuate that language if necessary, but otherwise I have no objection to that
She just
amendment.
showed it to me. But everybody else, just so you understand, and then the rest of the amendment that's being proffered by Senator. But first, let's take Senator San Augustine's amendment. Is there any objection to Senator San Augustine's amendment to the amendment? Any objection? If not, San Augustine's amendment is... Senator Espadon? No? Okay. No objections, so it's San Augustine's amendment is approved. Now on the amended amendment by the Speaker, Vice Speaker, any senator wish to be heard? Senator Nicholas.
Thank you, Mr. Speaker. A number of items. First, starting on page 32. We discussed in a prior day the lines 14 through 17. And in communication with the Attorney General, it became clear that this particular section A on page 32 has a unique purpose in terms of prosecution. It reads, any person who, in reckless disregard for the safety of persons or property, operates
Senator, we're just on her amendment yet.
Oh, I'm sorry. I thought we already passed the amendment.
So is there any objection to the Terlahi amendment as amended by Senator San Augustine? No objection? Okay, so Vice Speaker, do you have any further amendments? If not, Senator Nicholas, you are recognized.
Thank you, Mr. Speaker. Apologies for that. So on page 32, lines 14 to 17, it reads, any person who, in reckless disregard for the safety of persons or property, operates a motor vehicle while driving impaired shall be guilty of a petty misdemeanor and shall not be considered a prior conviction under section 92102. In discussion with the Attorney General, it became apparent that at times when someone is brought in for their first offense, because of the impact that a conviction under the strict first offender statutes may have on their long-term record, they are they are at times offered a reckless driving plea. And that is to be done in consideration of what the long-term implications may be if their record is impacted by the first offender. My concern is on line 16 to 17 with the language, and shall not be considered a prior conviction. Now, where that becomes problematic is, let's say, for example, someone gets taken in for DWI, and the courts ultimately resolve it by them being pled into a reckless driving charge. And then, okay, so that's technically their first offense, but it got pled down. This language makes it so that plea, that lesser charge, is not considered a prior. And so if they get pulled over again a second time, they would only be regarded as a first-time offender. because of that language. And, you know, I'm okay with our, you know, I may yield to prosecutorial discretion and the court's discretion with perhaps going down to a reckless driving one time. But if somebody gets pulled over a second time, I don't think they should be given a, you know, a pass to just be considered a first offender when that's actually the second time they've gotten arrested for a DWI. So in light of that, I still want to give them the flexibility of having that plea range, but I don't want a second-time offender to be considered a first-time offender just because they were able to get a plea on the first time. So I would like to strike on line 16, I'd like to add a period after the word misdemeanor and strike the rest of the sentence, so that we are not statutorily enumerating that it is not considered a prior conviction.
So the first Sir Nicholas amendment is to put a period after the word misdemeanor on line 16 and strike the word starting with "and" to the end of the sentence. Any senator wish to be heard on the Sir Nicholas amendment? Is there?
I just want to state that, yes, we did have discussions yesterday, and I have no objection to this amendment. Thank you.
Thank you. There being no objection to the amendment passes.
Thank you, Mr. Speaker. On page 33, on lines 9 and 10, there's a reference to occupational driving privileges. It was brought up in a prior day that we did not define occupational driving privileges. What was intended was for that to reference a later item in the bill on page 42, line 9. There is a section there for occupational driving permit. And this is apparently a practice that the courts currently employ, where they create a permit for a first offender to be able to drive for purposes of work. So I just wanted to narrow the language here so that we're speaking directly to that permit and not to just a blanket driving privilege. So the First Amendment, in order to tighten that up, would be on line 9, strike the word "with" and add the words "which may include." That would be the First Amendment. Page 33, line 9, after the word "months," strike the word "with" and add the words "which may include."
Is everybody clear on this Sir Nicholas amendment? Is there an objection? There being no objection, amendment passes.
Thank you, Mr. Speaker. And then to further that intent, on line 10, after the word "driving," add the word "permit." So it will read, "which may include occupational driving permit privileges." And that would speak directly to page 42, line 9, occupational driving permit.
So you're putting permit privileges, both?
The word "permit" after the word "driving."
So are you striking privileges or just putting both, permit privileges?
Occupational driving permit is specifically spoken to on page 42, line 9. We could, I think it's okay to just add the word "permit," or we could add the word "which may include unoccupational driving permit."
Period. Okay.
Period. Striking the word "privileges."
So the amendment is to strike privileges and to put permit on line 10. Any objection to that amendment? Hearing and seeing none, amendment passes. Anything else, Senator Nicholas?
Yes, Mr. Speaker. This gets a little bit more complex. On page 34, it was mentioned another day that we don't change the penalties, but we actually do in this bill. On page 34, line 11, we talk about third offender convictions. And on lines 23 and 24, the mandatory fine is actually reduced on third offender convictions. If we go back to the original language that's being stricken through, the original language is on page 11, starting on line 4. The original fines were a minimum of $4,000 and not to exceed $7,000. But in this bill, we're reducing it to $3,000 and $5,000, respectively. And I'm not previous to the logic behind the reduction, but I mean, a third time DWI conviction, I don't think we should be reducing fines for that. I'd like to make a motion to amend that to the original amounts of $4,000 and not more than $7,000.
It's on line 23 and 24.
Yes, Mr. Speaker.
Is everybody clear on this Sir Nicholas amendment? On page 34, lines 23 and 24, to amend the numbers there to read 4 and 7 as opposed to 3 and 5. Senator San Augustine.
Mr. Speaker, I just have a question because on page 35 on the fourth offender, they have the 4 and 7. Does he intend to increase that? Does the author intend to? I thought I asked that. I mean, why have it twice?
If I may clarify, Mr. Speaker, if you go back to the original statute, there's no language in there for a fourth conviction. And so what they've done in this bill is they've created a fourth conviction, and the fourth conviction amounts are consistent with what would have been a fourth conviction on the original statute. So what's happening is we're just reducing the third offender, and we're making the fourth the same as what it would have been under a third.
So that was just a comment. Let's stay on this amendment. And is there an objection to Vice Speaker? You're recognized.
On the amendment, Mr. Speaker, you're right. I mean, it was correct that the previous law had third offense and up. That's how it pretty much described. So everything from 3 and up, third offense and up, was going to be between 4 and 7. I have no objection to raising this penalty. I tried to restore all the penalties I could. This one, because it was an anomaly, we just put 3 and 5 and put the 4 and 7 for the 4 and up. But I have no objection to that, Mr. Speaker, if we want to increase the penalties.
On the amendment, the proffer of the bill has no objection. Any other senator wish to be heard? If not, then the amendment passes. Senator Nicholas, you still have the floor.
Thank you, Mr. Speaker. Also, with respect to penalties, the revocation of a person's driving privilege under the original third offender statute, the revocation was for a 5-year revocation. This bill would reduce it down to a 2-year revocation. And, you know, third offense DWI, that's the third time that you got caught. I mean, who knows how many times you didn't get caught. I really think that we shouldn't be reducing the revocation of driving privileges for third-time offenders. I would like to make an amendment to reduce that, to restore that to the original language, which had that at a 5-year revocation of a person's driving privilege for the third offender. The amendment is on page 34, line 26. If you want to reference the original statute that's stricken, it is on page 11.
The language on line 26 does have a number, but there's also a proviso right after that, which time period may be reduced to the discretion of the court. Do you still wish to move to have that 5?
Oh, yes, Mr. Speaker, I'll be addressing that second provision at a later amendment.
Okay, so the Sir Nicholas amendment at this point is line 26 to change the 2 to 5.
The original statute, Mr. Speaker, is referenced on page 11, not less than 5 years on line 18. That was the original statute on third offender.
Okay. On that San Nicolas amendment, changing the number from 2 to 5, Senator Estevez.
Thank you, Mr. Speaker. I don't have an objection to the amendment, but I just wonder how that coincides with the fourth offender. Because at 5 years for a revocation of the person's driver's license, let's say they were to do the full term, if looking at the fourth offense as a felony conviction, there's a statute of an occurrence only within 7 years. So that would put them outside of it. So at the end of that, it would almost be like a clean slate. Whereas, again, I understand the intent to try to keep them off the road, but I think a fourth offender conviction, as we're looking at it, is a felony punishment. We may not be capturing those individuals that are constant offenders. And I'm just wondering how that would coincide with 92-107. Just wondering if, just food for thought.
Thank you. Let's stay with the amendment, the 2 to 5 on 26. Any objection? Senator Torres?
Mr. Speaker, I object on the grounds that we're playing with numbers that perhaps have a reason behind why this rehabilitative court is proposing a staggered nature of fines and mandatory suspensions and the like. And without any rhyme or reason, I just feel very uncomfortable with toying with these numbers just arbitrarily. It begs the question of whether this really needs to go back to committee so that the authorities and the subject matter experts on the rehabilitative nature of this driving DWI court can rationalize the particulars about one number, one sentence, one mandatory threshold over another. But to do it here in this body, in this manner, I think is very inappropriate, and I don't think it does justice to the intent of the DWI court and the nature of it, of the rehabilitative program. So on that basis, I object. I just think that I almost feel like we're shooting from the hip, and I can't justify why I would want to support an amendment like that. And, that essentially is it. Thank you.
Thank you, Senator. Vice Speaker, you're recognized on this Nicholas amendment.
Thank you, Mr. Speaker. I see the rationale for the amendment, and it was my feeling on the fines that despite the request of the court to reduce the fines, that they should stay in place and that the court be given the flexibility if they found all these other conditions to apply, that they would have some flexibility there. Particularly, especially or only for those who attend the DWI court, because not all persons who are convicted are going to be able to, go through this special process or, to try to be rehabilitated. Some of them will not qualify. But anyways, as to the time for the driving, I just think throughout the bill there's many provisions about the driving and the flexibility of the court. And it seems to me from the testimony at the hearing from the presiding judge who has actually been implementing this program, and from the Attorney General who used to implement this program at the court, yes, this driving privilege is something that they really want to use as an incentive. So I did not change their requests in any way as to those years, because that they feel like is the most useful tool for them to try to entice these people to comply with the program requirements. So just for that reason. Otherwise, I agree we need to be strict, and we need to do it. But I'm going to have to put a little trust in the courts at that point for the just for the driving privileges. That I don't think they want to see any drunk drivers on the road. So I'm hoping that they will not allow them out if they have not complied with the program, and that they do not get their their license is restored. Thank you, Mr. Speaker.
Thank you. Senator Nicholas has proposed that the number be changed to five, I'm sorry, to 5 on line 26. And I just remind the colleagues that there is a proviso afterwards that it may be 5, but it's subject to that the court may reduce it. So whatever the number is subject to the discretion of the court. So it can be 2 or 5, and it'll be up to the court whatever the number is anyway. So there's been an objection. Senator Espaldon, you wish to speak on this motion?
Thank you, Mr. Speaker. The proffer of this amendment basically puts the argument forth that present law right now calls for a period of not less than 5 years for a person's privilege to operate a motor vehicle. Basically, it's a mandatory at this point. The language that is being proposed now basically says that revocation of a person's driving privilege for not less than 2 years. In other words, the way I read that is the court has the flexibility to even impose higher than 2 years if they should so deem it appropriate. So if the court says, well, 2 years may not be enough, bottom line, 2 years is the floor. The court could actually say, well, 10 years, that's the way it is. So I guess in terms of giving the court that flexibility, and again, a previous speaker, a colleague of ours, said that, well, we don't know what the intent was of the courts when they implement the specialty courts, the DUI courts or the drug courts and whatnot, right? That maybe they do want that flexibility, the floor being 2 years, but after 2 years, but that's the floor. The court has that ability to say it's going to be 5 years, it's going to be 7 years, it's going to be, whatever they deem appropriate for that particular defendant in this case. So I would probably have to object to that because 5 years might be a little too strict in the court's eyes, at a minimum, because if we set it at 5, that would be the floor, right? And, like I said, right now as the legislation is written, 2 becomes the floor, but it doesn't prohibit the court from imposing a higher term in which driving privileges are taken away. Thank you, Mr. Speaker.
So the amendment being proffered is to read on revocation of a person's driving privileges for not less than 5 years, which time period may be reduced at the discretion of the court, provided on motion by the defendant that a whole set of things be. So what the number will be set by the court. And the floor can be 2 or 5 or 10 at the discretion of the court. Yeah.
Correct. However, if we change it to 5 years, then the minimum time that the court could reduce it by 50%, which would be 2.5 years, would be 2.5 years. Perhaps the drug courts or the alcohol courts might want that flexibility that maybe in certain situations it shouldn't be that high, depending on the circumstances of the individual who is being brought to court. But like I said, it does not prohibit the court from actually imposing a much higher revocation of a person's driving privileges to more than 2 years. In other words, they can go up to 10 years, they can go up to 50 years if they want, but it doesn't, impair the court's ability to do that. All I'm saying is that perhaps, and this is where a comment by the previous speaker said, that without knowledge of the intent of the recommendations by the court and why they're lowering the threshold from 5 years to 2 years, right, then we're only speculating. But the point that I'm trying to drive home is that 2 years is the floor. The court has the ability to raise it higher, but they might want that flexibility to be able to reduce the 2 years, the floor, by 50%, right, depending on the individual situation and the facts of the case before them. Thank you, Mr. Speaker.
Thank you. Any other senator wish to be heard on this Nicholas amendment changing the number from 2 to 5? On this amendment, any other senator wish to be heard? There have been objections. Do you wish to close?
Thank you, Mr. Speaker. I'm a fan of our court system. I think that we definitely should encourage them to do their jobs as effectively as possible based on their ability to render judgment. It's their primary function. Our primary function, however, is to set the parameters that we feel are necessary to keep the community safe. And we're talking about revoking driving privileges from people who have been caught driving while intoxicated. Let's be very clear, Mr. Speaker, this bill isn't just a simple bill to change a couple things. This is a complete rewrite of our DWI statutes. And it's a transition from a more punitive system to a more therapeutic system. I wish the title could have been a little bit more transparent in that, because that's what's happening here. The DWI laws that we've had in place that were very, very clear, now they're going to create more flexibility for the courts to be able to try and move the perpetrator through a more therapeutic process, trying to reduce recidivism, all those kind of things, and those are important. But when we're talking about third-time offenders, the third time you got caught, that doesn't mean it's only the third time you were DWI. That could have been the 30th time. In the eyes of the court, it'll only be the third time. By reducing the revocation of the driving privilege down to 2 years, that just really concerns me as a policymaker, Mr. Speaker, because are we then saying that after 2 years, someone who got caught 3 times driving while intoxicated, we're going to go ahead and let them back on the road again as a matter of policy? Driving is a privilege. And it's a deadly privilege if you're intoxicated. First time, we even have in here, they even have the whole wet, reckless driving plea. First time, second time, those are the times that you're caught. Okay. But now we're going to get down into a third, and we're going to say you're only going to lose your driving privilege for 2 years. There comes a point where we need to make sure that we're taking people off the road. And I don't want to wait until someone gets killed because they're trying to be therapeutic. So when it gets to the third, when it gets to the fourth, I am making amendments to restore that more punitive aspect, because we have a community to protect as well. And while we do want to reduce recidivism and we do want to help people to recover from their addictions, not at the risk of people getting killed. So that's the amendment, to restore it back to 5 years, and let's keep a third-time offender off the road for at least 5 years. Thank you, Mr. Speaker.
Thank you. There's been an objection to the amendment. All those in favor of the amendment, please indicate by raising your hand. Amendment fails. Your next amendment, Senator Nicholas.
Thank you, Mr. Speaker. So now we only have a 2-year revocation The language immediately after that allows for the courts to reduce that 2-year revocation by 50%. So it can be just a 1-year revocation for a third-time offender. Starting on page 34, line 26, after the word years, it says specifically which time period may be reduced at the discretion of the court, provided that they've completed treatment, paid all fines, not been charged with a subsequent criminal offense. Mr. Speaker, on the second offender section, we do have a therapeutic, the same therapeutic language. The sentences can be reduced, the incentives can be provided. You go through that very same process on a second offense. If you go through all of that after your second offense and then you come back in as a third offender, why do we keep putting the same people through the same process, giving them the same incentives, reducing the revocation of their licenses, incentivizing getting them back on the road, if after the first time we put them through that process, they came right back into the system? I think that pursuing a therapeutic avenue is something worthwhile, but I don't want to just go from one extreme to the other, where we're going from purely punitive to purely therapeutic, and we're just constantly trying to put people through alcohol treatment programs and getting them on the road faster as an incentive. Perhaps we should take a half step, allow for that therapeutic component to remain in the second offender, which I have not tried to amend out. But once you get down to third offense and fourth offense, I don't want sentences reduced or suspensions reduced. There comes a point where you become a danger to yourself and to others. So let's support a therapeutic component for a second offender, but I'm very leery about going that far for a third offender and then creating a whole new fourth offender. So I guess just to get on the record, make a motion to strike on line 26 after the word years. Strike all the way to line 8 on page 35 after the word court.
This St. Nicholas amendment is to put a period after the word years on line 26 and strike everything after, beginning with which, from line 26 on page 34 to the end of line 8 on page 35. Senator Torres, there's an objection. Vice Speaker.
Thank you, Mr. Speaker. I totally appreciate the sentiments of my colleague as to protecting the public, and I assure you I very much hope that that is going to be what the courts do. And I just want to reiterate that it is their request that they be given flexibility, particularly with driving privileges, because they feel that is the most effective tool that they can use. I also just want to point out that part of the language that's going to be deleted is what I feel is one of one of my favorite parts of this bill is that it says the court may further reduce the period of suspension by no more than 50%, provided the defendant agrees to have installed either a breath alcohol ignition interlock device as ordered by the court or an electronic alcohol monitoring device approved by the court. That's another tool that the courts would like to use, and I would very much like to see them be able to use that. I think they are trying to keep people employed instead of imprisoned, if they feel it is appropriate. And I think we've given them, with all the minimums and the flexibility to go, as a previous speaker said, as high as they want, really, in terms of revoking these privileges. They can revoke them for a much longer period than 2 years. That they are the ones who will be seeing the facts of the case, and they will be the ones who will be seeing whether the treatment is effective. They will be the ones who will be seeing whether any of these incentives are effective. And if not, then I hope they will act likewise. But this particularly object to the strike through of all this language, especially because it's going to take away another tool, 2 tools really, and I would really like to see this other tool be put in place, the electronic alcohol monitoring and the breath alcohol ignition interlock devices. Thank you, Mr. Speaker.
Thank you. Senator Torres, do you wish to speak?
If I may add, Mr. Speaker, to that, the other thing I want to focus our attention on is the fact that these rehabilitative courts are a different focus from the old school throw the book at offenders approach that we have become accustomed to. And I object to this on the very basis that people with substance abuse issues are now viewed more as in need of people who have conditions that are illnesses, perhaps, that need to be treated appropriately and addressed, as opposed to just penalized in the old-fashioned way. And that is why we have to give the courts, in order for them to succeed in the rehabilitative nature of these court programs, we have to give them the flexibility to make that distinction and discern what is their most appropriate per client approach to the administration of justice, not only to the community that they've offended, but in their obligations as citizens of that community. So we have to give them that latitude, and we can't just have the notion that it's purely a crime and that these people aren't really victims of another type of affliction, which is oftentimes substance abuse, which is an illness in and of itself. Thank you, Mr. Speaker.
Thank you. Any other senator wish to be heard on this Nicholas Amendment? On this Nicholas Amendment, any other senator wish to be heard? Do you wish to close?
Thank you, Mr. Speaker. I don't disagree with the sentiments of the previous speakers. That's why we try and do it on the second offense. The same language that I'm deleting on the third offense is still in place on the second offense. The incentives can be there. The alcohol ignition locks can be there. We can try all those tools on the second offense. If they come back as a third offender, we're going to do the same thing all over again? I'd just like to point out a couple things. This alcohol ignition lock thing doesn't stop them from getting behind a wheel. It just stops them from getting behind that one wheel. And if it's about people getting to work, let's not use our inability to properly implement a public transportation system. Let's not use that as, if we had that, people can get to work all over the place. The third offense, Mr. Speaker, I think we need to, there comes a point where we need to give all the opportunity, create all the incentives. We do that on the second offense. But by the time we get to the third offense, I think it's time for us to start stepping back and looking out for the safety of the community. Mr. Speaker, this third offender could have a child in the car on that third offense. They could have a car full of kids. So I support the therapeutic aspect. I'm totally down for that. Let's give it a chance on the second offense. But let's also know when we're trying too hard to be optimistic and we need to just protect people. There are definitely lines in the sand as to where we need to start looking out for protecting other people and protecting people from themselves.
There's been an objection to the Nicholas Amendment. All those in favor of the Nicholas Amendment, please indicate by raising your hand. Amendment fails. Senator Nicholas, you still have the floor.
And this takes us, Mr. Speaker, to the fourth conviction. Page 35. We reduce the revocation of driving privileges for a fourth conviction. It used to be 5 years, we're reducing it down to 3. The fourth time you got caught could have been the 400th time you got behind the wheel. My first amendment, Mr. Speaker, is to amend that from 3 years back up to 5 years to revoke the driving privileges of a fourth offender.
I'm sorry, what line was that?
Page 35, line 24.
We want to change that to 5. All right, so on line 24, change 3 to 5. Any objection? Any senator wish to be heard? I'll go with Senator Torres, then Senator Estevez. Just an objection, Senator Estevez.
Thank you, Mr. Speaker. While I understand the sentiments of my colleague with regards to keeping offenders and those convicted off the roads, let's keep in mind that the fourth offender has a mandatory prison sentence of 1 year. And now there are programs available to help that individual with addiction. But after somebody serves their minimum 1 year incarceration, how much longer do we want to punish the individual? Do we want to set them up for success or for failure? Substance abuse is a disease, Mr. Speaker. That's something, and I think that's something that the court has identified. You know, there are individuals out there who can get 2 offenses within the span of a week, because maybe they didn't have adequate treatment for an issue with post-traumatic stress. And so I understand the importance of taking the holistic approach with a therapeutic court. But even with this, somebody who's already doing 1 year in prison, Mr. Speaker, how much more are we going to punish them after they've done their time? I stand with the studies and the research and the knowledge base behind these timelines and these systems, Mr. Speaker, and I stand in opposition to the amendment. But I do understand the sentiments. But we need to give them and allow them to do the work that they set out to do and to run this program as they see fit as the subject matter experts. Thank you, Mr. Speaker.
Thank you, Senator. The green I'm wearing is for Mental Health Awareness Month. Vice Speaker.
Thank you, Mr. Speaker. On the amendment, yes, I echo the sentiments of the previous speaker and the concerns that are being addressed here, and I welcome them. I think my initial reaction, I'll just share it with you, was, you know, I'm one of those, I want no mercy when it comes to drunk driving. But, you know, because I'm chair of this committee with the judiciary oversight, you know, I really took it upon myself to listen to them and to try to figure out why it is that they would want to see any kind of reduction in, you know, privileges, and how that would help us. And I take a lot of comfort in the fact that they actually have been, administering a DUI court currently, and that many of these recommendations from them, and it's not just one person, it's an entire DWI executive committee that they created over there. It's all of their recommendations with all of their experiences and all of their shared concerns that we also have, but it's their implementation of the current drug court that is compelling them, I believe, to ask for even more flexibility. And it's not necessarily, as the AG is very fond of pointing out, to curb that first-time DWI, because she thinks that the laws that the legislature has passed, if I may speak for her, I hope I don't misstate it, but that have been very effective, the ones especially that change the drinking hours, she always cites those as being very effective in curbing drunk driving and drunken driving fatalities especially. And you know, the incarceration and the sobriety tests that they are doing, that all of those have worked together and very much curbed the first-time drunk driving offenses. It's these repeated offenses, and these are the ones that it looks to me the drug court is having the biggest problem with, in trying to deal with these repeat offenders. And as a previous speaker said, it's because these are a whole different kind of illness. It's therapy, or they will never be rehabilitated, and we will continue to see this. And as previous speakers have said, we can pass all the laws we want. That does not prevent somebody from getting behind that wheel drunk, unfortunately. You know, we don't have a physical ban on that. We do have a potential incarceration. That's the closest we're going to get to a physical ban on drunk driving. But so without that, we need to work with these people that the courts are seeing as repeaters. And they, I think, have very sincere intentions, them and the executive committee, the Office of the Attorney General, who it is their responsibility to prosecute those. And so I take very seriously that they also do not object to reducing these privileges, or the reduction on, you know, as is being proposed here. That's important to me, because they are the ones who have to prosecute these things, and the public defender, alternative public, and even the Guam Police Department. So the Guam Police Department was very clear. They did not want us to reduce whether it was a felony or a misdemeanor, and they supported that we not reduce the fines, but they did not object to the reduction in the other, or the changes that we are making, and giving that flexibility to the court and its probation officers, you know, to oversee these people who are in the system, who are in the therapeutic rehabilitation, so that they're supposed to keep a close eye on them, and I'm sure alert the court if they see the need. But anyways, I'm just saying, there were very many people involved, and I can't know everything, but I do know that because they are implementing this court and they have seen it firsthand, the repeat offenses is what they are trying to get at. I just want to give them the tools that they think are necessary to complete that mission. Thank you, Mr. Speaker.
Thank you. Senator Nicholas has made an amendment. It's been objected to. Any other senator wish to be heard? If not, Senator Nicholas, I will invite you to close.
Mr. Speaker, we're talking about the fourth conviction. Yeah, they sit in jail for 1 year. The revocation of that license for 3 years already starts that 1 year clock. Subsequent language allows for that revocation to be reduced in half. So technically they could be in jail for a year and get out 6 months later, they get their driving privileges restored. And if this whole therapeutic idea works, why are we stopping at fourth offender? Why don't we create a provision for fifth offender, sixth offender, seventh offender? At what point, Mr. Speaker, does it become a concern for the community and we need to make sure that these people are not being enabled?
Thank you. An amendment has been proffered. There's been an objection. All those in favor of the amendment, please indicate by raising your hand. Amendment fails.
Thank you, Mr.
You
Speaker.
still have the floor. Yeah.
Thank you. The trend is clear, but just for the record, it has to be shown that the effort was made. The same language exists for a fourth conviction, that the sentences can be reduced, the revocations can be shortened, trying to incentivize a therapeutic process. I'm concerned that those incentives are actually, at this juncture, creating windows for greater risk to be placed upon our community by somebody who really shouldn't, they really shouldn't be allowed to drive anymore. It's a privilege. To infer that this is a punishment, that's incorrect. This is a privilege. Driving is a privilege. And the most important component of that privilege is that you should not abuse it. It should not become something that's going to present a danger to yourself or to others. It shouldn't be the process by which we're trying to combat alcoholism. My amendment, Mr. Speaker, is to strike after the word years all the language from lines 24 to page 36, the language on line 6.
Can you please state that again?
Yes, Mr. Speaker, on page 35, starting on line 24 after the word years, add a period, and strike all of the language after that period into page 36, line 6.
Does everybody see that amendment? The bottom of page 35, after the word years, to the top of page 36, to line 6. Any senator wish to be heard? Senator Estevez.
Thank you, Mr. Speaker. Once again, I stand in opposition to this amendment and similar amendments. And let's be very clear, Mr. Speaker, that there is a process in place, and there are many people involved in this therapeutic program that the court is trying to put together. When somebody goes through this program, they have a probation officer, case manager, therapists, people that are involved with these individuals almost daily, that know what's going on in their life. And so I do have issues that here we stand on our golden tower as politicians trying to dictate the outcome of that individual's life and their trajectory forward when we may never even see that individual face to face and look them in the eyes and say, you don't deserve another chance. I want to leave this in the capable hands of the Therapeutic Drug Court, or DWI Court, correction, where the therapists, the probation officers, even the judge can all work with the individual and their family and look at them in the face and understand their particular situation and give them the respect and dignity as citizens of this island to have a more positive trajectory forward. We've seen it. We've seen in many jurisdictions. I mean, the studies are out there. Just throwing the book at it doesn't work. What we're trying to target here, this court is not for everybody. That's already been addressed and put on the record. This DWI court is not for everybody. Not everybody qualifies for this. But the individuals that do have an illness. They have a substance abuse problem that we're trying to address. I think everybody here wants our streets to be safe. And I think everybody here wants the most positive outcomes for our citizens who are in these types of situations in troubled times. How we go about that, we may disagree, but let's just be very clear. There are systems in place. Taxpayers pay for these people, probation officers, judges, therapists, psychologists, case managers. And let's put them to task. Because not only are they tasked with working with these individuals, they know best what is going on with them. Let the system work, Mr. Speaker. And let's not try to judge from atop our pedestals what's going on down there. Again, without maybe never seeing that individual, shaking their hand, looking them at the face before passing judgment over them. And let's allow the courts to do what they're supposed to do and pass judgment. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard? There's been an objection posed. Any other senator wish to be heard? You may close, Senator.
I don't think there is a single family on this island that doesn't know someone who is battling with some kind of hardship, alcoholism, drug abuse. It is a very sad part of our community. I think we have major failings, Mr. Speaker, are failing to provide adequate public transportation, are failing to have a really effective Guam behavioral health and wellness operation. So many failings, Mr. Speaker, that are the reason why there is so much suffering. There's so much suffering from alcohol abuse and drug abuse. We need to remedy those failings. I mean, I have resolutions, I'm trying to fix the finances of this government, trying to make sure the resources are going to be there for us to address these things. I fight pay raises, I fight increases of the cost of living that drive more people to drink. And in all those stances, Mr. Speaker, I certainly am not on any ivory tower. I kind of get rolled around a little bit on the ground. But it's the solution. Reducing the existing statute on keeping people off the roads who have drug and alcohol problems is not an act of compassion. It's an endangerment. If someone's on a fourth offense coming before the courts have a problem with their program. If they went through it on the second offense and then on the third offense and they're back on the fourth offense. And we're going to trust that program should, because they're the experts. There comes a point where we have a job to do here too, Mr. Speaker. If the program isn't working, they need to fix it before it gets to the fourth level. Instead, we're going to say, no, let's just do it because you never looked into that person's eye. Every parent who looks in the eyes of their children, every grandfather who looks in the eyes of their grandchild, There comes a point where we need to be rational about how much therapy we want to give and how that may not necessarily be the right thing at this point because it's going to endanger the eyes of those little ones. I certainly don't want to attend a funeral of someone who passed, a child, because we're trying too hard to be therapeutic. Let's get them on the second offense. Let's put them through the therapies on the second offense. But let's start protecting our people when it becomes very clear there's a third and now a fourth offense. Sometimes I wonder, Mr. Speaker, if the problem is because I'm the one raising the amendment. Perhaps if someone else raised it, it wouldn't be just so knee-jerk opposed. But at what point on the fourth conviction, we're now going to create reductions in sentences and incentivize them getting back onto the road because that's what's attractive? They want to be able to drive? That's what's dangerous. We have a duty to, yes, support our courts, but to also protect our people. That's why we have 3 branches of government. That's why this has to be passed into law. So we don't abdicate our responsibility to look out for our people in the policies that are being adopted by this territory and made into law.
There's been an objection. We'll take the vote. All those in favor of the amendment striking, please indicate by raising your hand. Motion fails. Any further amendments? Senator Esteves.
Actually, Mr. Speaker, just a point of inquiry. There was a previous amendment by the good senator from Derrida in adding the word driving permit, adding the word permit between privileges. And since we didn't have that amendment passed out, I just want to confirm, did we make the subsequent amendment for consistency on page 33, line 26 and 27? All right, thank you, Mr. Speaker. So at this time, I'll just go ahead and proffer that amendment just for consistency's sake. On lines 26 to insert the word permit after driving, and line 22nd to insert the word permit after driving. Or I'm sorry, just on line 27, inserting the word permit after driving to be consistent with the previous amendment made under the first offender conviction section.
Any objection? Hearing and seeing none, amendment passes. Was there a second place? Okay, thank you. Senator Espaldon, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, on page 33, under subsection D, starting on line, let's go line 10. Basically, this area speaks to the suspension of a person's driving privilege for 6 months, which may include occupational driving permit privileges. And then it goes on to say the court may modify this suspension prior to the end of 6 months suspension, provided the person can show proof that he or she has successfully completed a drug and alcohol treatment program acceptable to the court. The issue I had raised when the Attorney General was here yesterday is that if, and this comes under the first offender conviction, bottom line, if somebody was convicted for the first time of perhaps driving while under the influence of, or driving while impaired, having used alcohol, the question became, do they need to then complete a drug and alcohol treatment? And so I would like to change, or at least to add this, and with the concurrence of the Attorney General, on line number 12, it should be after the word drug, it'll be and/or alcohol treatment. Oh, that amendment was made already? Oh, okay. Was that amendment made already? It was just an issue that I was just informed by a colleague that that amendment was made, but I'm not certain.
Was included in the amendments to the entire section, yes, on your advice yesterday. So that actually was made already, Mr. Speaker, but I thank the sponsor.
Okay, well then in that case, Mr. Speaker, I apologize, but yes, I will then withdraw this amendment. Thank you.
Thank you. Any other senator wish to be heard on the main motion? On the main motion? On the main motion? If not, Vice Speaker, you're welcome to close.
Thank you, Mr. Speaker. And I want to sincerely thank my colleagues for the discussion on this bill, the debate on this bill. It is not a simple bill. It's a huge piece of legislation physically, and it's a shift. It's a shift in policy. It does not shift, and I want to make this very, very clear because I think there have been some statements that actually say the opposite. This bill does not reduce current fines for drunk driving. It does not reduce imprisonment for drunk driving. And I especially want to point out that there is a minimum of 1 year of incarceration, a mandatory minimum, and we have not given the judges flexibility in that under this bill in reducing that mandatory minimum incarceration. This does not change the mandatory, this does not even touch actually what happens when you are caught driving on the road and whether you're going to be put in jail for 48 hours or not. This doesn't touch any of that. The main focus of it is to give the court tools, which include allowing the court to, it gives them minimum revocation of a person's driving privileges, but allows them flexibility to alter that depending on the person's behavior, their treatment, and the effectiveness of that treatment. It also requires that the persons who have been found driving impaired are going to be under probation for an appropriate amount of time, even after incarceration. So I think it's another attempt, and as criminal justice in general throughout the nation shifts, and it is shifting away from incarceration towards therapeutic courts, and it is shifting in many other ways to save costs for government, from incarceration to electronic monitoring or different use of technology that will also save costs. In all these ways that the courts shift, it's almost, we rely on studies that are being done. We rely on actual practices of courts that have implemented these things and their successes. And in this case, we have our own courts which have implemented this program on a small scale, and they believe it is effective. And I very much agree with this is just one aspect of what we need to do to take care of drunk driving on Guam, substance abuse, and this is just for those who have been put into the court system to give the courts the flexibility that they have asked for, in particular for these types of cases, and which the police department agreed to, and the attorney generals agreed to, and the public defenders agreed to, and the judiciary's executive task force agrees to, and actually, I believe they've received federal funding for the beginning of this program, because it is what is been found nationwide as this is the program that they are urging governments to implement. So I just want to thank again my colleagues for their support in this bill. When we find, and I agree also that we can make our own determination as to whether this is effective or not. And I am very glad for the testimony that talks about its effectiveness. And I don't think we would be going down this road if they did not, people who are implementing it did not believe it could be effective. Because that would just be reckless and negligent. And I don't believe people put their careers and to be judges and lawyers and police if they wanted, to put us more at risk. So I absolutely appreciate, though, all the improvements that have been made to this bill. I want to thank the executive team that worked on this at the judiciary side. I want to thank all my colleagues here who have helped me to work on this bill and to make it better. And I very much hope for its successful implementation at the court, and that we can see statistics soon that will show us that it is effective or what needs to be changed as soon as possible. Thank
you very much, Madam Vice Speaker. On the motion to send the bill down, any objection? Hearing none. Senator Nicholas, you're recognized on your resolutions.
Thank you, Mr. Speaker. I'd like to make a motion to place Resolution 311-34 on the third reading file and be afforded an opportunity to speak on the resolution.
Hearing no objection.
Thank you, Mr. Speaker. Resolution 311-34 is relative to respectfully petitioning the United States Congress pursuant to 48 U.S.C. Section 1423K to enact legislation amending the Organic Act of Guam to include a provision of Guam Public Law 24-222 that any provision enacted and administered on the authority of the government of Guam which establishes a locally enacted tax or increases a locally enacted tax must be ratified by majority of votes cast in a general election with allowances for a state of emergency if so ratified by a 2/3 vote of the Guam Legislature. Mr. Speaker, the purpose of this resolution is to put into our Organic Act the requirement that if we're going to raise taxes on our people, the people need to ratify it. And on the surface, it may be regarded as an impediment to the government being able to operate. But the reality is that we do create a 2/3 vote provision in here so that if there's any kind of emergency, whether it's declared by the governor, identified by a resolution of the legislature, or even rendered by the federal government, the legislature can, by a 2/3 majority, affect any local tax. So we're not stopping completely the ability to raise taxes, but what we are doing is we're creating a higher threshold for it. In the Organic Act, as we've encountered, there are thresholds to passing a bill into law. What this resolution would ask for is to create a threshold for us to make a tax go up. And it can either go up with a majority vote of 8 being put to the people and being ratified by the people, or it can go up with 10 senators in this body voting to raise it and a state of emergency being declared. Why would we want to do something like this, Mr. Speaker? Why would we want to ask our people whether or not we should raise their taxes? I think the initial perspective is that the people would never want to raise their taxes, so they'll never go for it. So why are we doing this? They'll never want to do it. But I actually have a different mindset when it comes to our people. I believe that if our people see a government that's managing its money well, that's fulfilling its responsibilities of the resources that it has, and then it goes to the people and articulates a case for any kind of increase in revenue that is going to provide a result that is tangible, I think the people will get behind it. All of us encountered people who have come up to us, or even organizations who have said to us, perhaps the property tax can be increased. I mean, there's discussions about these things. We don't have an anti-tax community. What we do have is a community that's fed up with a government that spends hundreds of millions of dollars more over the years and has nothing to show for it, if not less to show for it. You rewind back a decade, 2 decades, and this government was operating on a $300 million budget. It's now being almost bragged about that our budget is almost $1 billion. $1 billion. Triple what we cost to operate a decade, 2 decades ago. And yet we step back and we ask ourselves, have the services on this island improved by 300%? Do we have 3 times as many police officers or 3 times as many teachers? Are our roads 3 times better than they ever been? Does our government respond 3 times faster when it comes to processing or getting things done? It's been actually the opposite, Mr. Speaker. Our cost to operate has gone through the roof. We've incurred so many liabilities, not just in terms of debt, but in terms of general operational expenditures. We can't even walk them back anymore. And so when we require that the people have to ratify tax increases going forward, we're creating the environment in which our people will be able to hold us accountable and say, yeah, you know what, you might want to raise taxes, show me why. Explain to me why. And by the way, what's the status on that other tax? And when our island and when our government and when our leaders get to a point where we're able to clearly articulate that, yeah, we're doing things right. Look, the audits are showing that we have a couple dings, but we're generally getting things going the right way. We're collecting everything we're supposed to. And people are able to look at their roads and say, yeah, the road money that we set aside for the highway fund is actually going to fix our roads. We're actually putting the money where we're supposed to. Once we're able to do that, I think we'll be able to get these things through. But our people need to be the ones to be empowered. It's far too easy, Mr. Speaker, to create an environment of fear and chaos, and then to cause just 8 elected officials to just go with it. We saw it recently. And every member of this body was gravely concerned because the circumstances that were being put before our people were alarming. The administration was closing fire stations and police stations, threatening furloughs, all to just get to 8. If we can just get 8, we're good. So let's create enough political pressure, let's scare the people enough, let's force them in enough, and let's get our 8. We're not even 2 months after all that, Mr. Speaker, and what's happened? We find out not only that we haven't been collecting over the last couple of years tens and tens and tens of millions of dollars in taxes that would have gone to address the hospital and gone to address DOE. We not only find out that we're not collecting that money, it's just been in recent reports that there's been hiring by the administration in the middle of all of that. The political gamesmanship, Mr. Speaker, when it comes to our finances, it's not something that's just going to go away. And if we're crossing our fingers that we're going to somehow get a magnanimous governor elected, or crossing our fingers that we're somehow going to get a magnanimous 15 senators elected and all this is going to go away, perhaps, but it'll only go away for that period until such time that the next administration comes in that's going to do the exact same thing. And that's why, Mr. Speaker, a law of the land is so important. And that's why governance as a policy is something so important and something that we've actually not been doing very well. We pass laws, we'll get the headlines, we'll have the talking points, but so many of those laws are just being so grossly ignored. And there's almost nothing anybody can do about it. It's almost like the solution to a law being ignored is to try and pass another law. And then to figure out, someone else trying to figure out how to not follow it. The only exception, Mr. Speaker, is the Organic Act. It has been the one law of the land that nobody has been able to get around, and you can't. Once it's in there, stuck. It takes an act of Congress to take it out. So we have to be very careful of what we put in there. And I believe that putting a provision in there that's going to require our people to ratify a tax increase is exactly the kind of law of the land that we need. Because then it's not just a matter of creating fear and chaos and squeezing until you get to 8 votes to raise a tax. You're going to have to really win over the people to get it done. Or you're going to have to declare a state of emergency. No state of emergency was declared over the course of all that drama. And if you declare a state of emergency, you're going to need to get 10 senators to agree that there is in fact an emergency. If this provision was in the Organic Act, Mr. Speaker, we would not have raised taxes. The GRT would not have gone up, the sales tax would not have been put into the books, because there wasn't 10 votes, and there was no state of emergency declared. Our people would have been protected. Maybe with the 8, you could have gone out for referendum, but then you better win over the people. Those are exactly the kind of safeguards we need in our law of the land, in our Organic Act. Once that's there, no administration, not this one, not any future administration, will be able to pull that same kind of farce. And what happens when we have a government that runs on that kind of fuel? I mean, aside from how demoralizing it is to our community, it literally hurts our people. Makes things more expensive. The cost of living goes up. Their ability to provide for their families, their ability to call Guam home, all that gets compromised, nickeled and dimed. Mr. Speaker, in just this legislature alone, there have been 15 tax increase bills. 4 from this body, 11 from this body, and 4 from the administration. Bill 8-34, 122-34, 142-34, 145-34, 244-34, 245-34, 248-34, 249-34, 253-34, 260-34, 261-34, Bill 1, 2S, 3S, 5S, 6S. A large chunk of those were just in the last 2 months. So much effort and energy expended trying to raise taxes on our people, nobody paying attention to the tobacco taxes not getting paid, the property taxes not getting collected. We even make appropriations to try and remedy those problems, only come to find out that they come back and it's some other excuse. But oh, let's raise the taxes because the fiscal team is all here saying that's what we need to do. We can make all of those games stop, Mr. Speaker, by creating the hurdles necessary for it to no longer be the way business is done around here. You need a tax increase without the consent of the people, you declare a state of emergency, and you get 10 senators in here to agree that that is in fact the case. 2/3 majority. And if it's a tax increase because you just want to have more revenue to go out and do something, put it before the people, so the people can be the final arbiters of whether or not you're using their money right. We can't just pass a local law to make this a requirement, Mr. Speaker, you know that. This needs to be the law of the land if it's going to be something enforced. Because even our own Attorney General said that no prior legislature can bind the hands of a future one. But if it's in the Organic Act, it is the law of the land, it will be the mandate that all of us have to follow, and it will be for the best interests of the island and the people of Guam, not just now and not just in circumstances like these, but going forward as long as the Organic Act remains as the law of this territory. Thank you, Mr. Speaker.
Thank you, Senator. Senator Estevez. After Senator Estevez, any other senator wish to be heard on the main motion? Senator Lee. All right. Thank you.
Thank you, Mr. Speaker. You know, I've done some research on this and seen that other state constitutions and jurisdictions that have since ratified certain provisions in their constitution to address this. You know, at face value, I'm not completely opposed to the idea of voter initiatives and ratifications involved in our tax process. But let's not be the only jurisdiction in the United States of America that completely takes an elected body out of the process. At most, what you would find in other jurisdictions, Mr. Speaker, is if there is a provision for voter ratification for tax increases, then it's either done by a 2/3 majority proffered within the body or by voter ratification. But this, limited to only a state of emergency, only provides for this body to react in an emergency situation. It takes away one of the core functions of this body. In our democracy, 3 branches of government. I mean, you learn that in the 3rd grade. Who's responsible for taxation? Who's responsible for the budget? And what we're creating right here, Mr. Speaker, if we go down this route, again, this specific resolution, completely taking away that authority from the legislature to vote by a veto-proof majority, 2/3 majority, by taking away that power, Mr. Speaker, we're creating the ultimate hand-washing station to where whatever problems happen, we wash our hands of it. Well, we can't do anything about it. We can't raise the necessary fees. Oh, well, the people didn't want it. It's not our fault. You know, we were recently just taken down memory lane, and I take a different perspective to it. We had a $300 million budget a couple decades ago. But what did we get from that, Mr. Speaker? We had a dump that was never closed, that went into receivership. We had schools that never got repaired or replaced to where now they're falling apart with our children in them. We had ailing infrastructure. Because what we had were, we had politicians who didn't have the courage to say, you know what, this increase is merit-based. We've looked at this objectively, and even though we don't want to do this, we feel that we must. That's what we're elected to do, Mr. Speaker. That is our responsibility. That burden is on us. This implication that we're so just lackadaisical that we go around increasing fees without any consideration, I think is an insult to this very body and bodies that come before, that these increases are taken lightly. We exist within a representative democracy. If we're trying to set a new trend where we're a government run by Twitter, then let's do that. I have no issues with involving the people in the process of governance, but not at the sake of stripping that responsibility away from the elected body designed to do that. You know, we've heard, Mr. Speaker, that, you know, look what happened in recent times. And I take a different perspective. I look at this body mixed up of people with different perspectives and views. And even through all the turmoil that was going on, this body stood resolute. We took the time. We had the public hearings. We had the debates. We did what we were supposed to do. And because maybe some of us don't necessarily agree with the outcome, we use that as a precipice to attack the systems in place, the systems that were working. Mr. Speaker, there are many challenges before us. And leaders come and leaders go. But this process is tried and true. The power of taxation and budgeting belongs to the legislature, to any legislature. And I will not stand by and watch us create a hand washing station till we could just blame it on somebody else. I don't believe that it's going to turn out the way that it's intended, Mr. Speaker. I think if it's going to be based only on a voter referendum outside of a state of emergency, then we're going to see more hearses outside. We're going to see Facebook battles, Instagram battles, media battles to try to politically maneuver and the political gamesmanship to win over the people's vote. When really what should be happening is the elected representatives of this island should be taking the time as a deliberative body talking about the merits, Mr. Speaker, the merits and objective arguments as to why or why not. But I refuse to relegate this body to remove half of our overall responsibility as a legislature and create an ability to wash our hands and pass the blame on, and then potentially turn this on to where any type of increase, whether warranted or not, is not deliberated on, but it just depends on who puts out the better message, who's better with media, who can be more dramatic. That's what I see is going to happen. I truly believe that's going to happen. And that's going to happen from, if this goes into effect, this is going to happen with administrations to come, with legislatures to come, and whoever. Because this really takes away from what it is we're supposed to do. To put on the record, as we're doing now, why we think something should pass, or why we believe something should fail, or should not pass. So I stand in opposition to this resolution, Mr. Speaker. But again, I want to be very clear on the record. I would support such an amendment to the Organic Act if it was a provision that provided for either a ratification of a vote by voter initiative, or by a vote of the people for a tax increase, or by a 2/3 majority, not necessarily just in a state of emergency. Because this body should be able to act when appropriate and deliberate. Thank you, Mr. Speaker.
Thank you, Senator. Senator Lee.
Suzos Masi, Mr. Speaker, and I just want to apologize to my colleagues. I'm feeling a little bit under the weather today. But I did want to rise and take the opportunity to really thank the sponsor of this resolution for thinking outside the box. All of the 3 resolutions that are on the agenda for us to discuss, you know, they discuss public indebtedness and tax refunds and tax increases. And many of us, as we go about our daily work and we talk to our constituents, a lot of these issues are some of the reasons why maybe they've lost confidence in our government in the past, and things that, you know, are very upsetting and difficult for many of us in our community to swallow. That being said, I have some significant concerns with the approach that we're taking to address these issues. I believe very strongly that we already have the tools to solve these problems. And as the retiring speaker had mentioned, one of the greatest tools that we have in our toolbox as a community is elections. And the fact that one is coming up in just a few months, it underscores that opportunity that we have to ensure that elected officials who are running are going to take these things, public indebtedness, tax increases, and making sure that we have the very timely payment of tax refunds paid back to our people, that we prioritize that and we do it as soon as we possibly can. So we have the tools to solve these problems, Mr. Speaker. These resolutions are respectfully petitioning the Congress of the United States to amend our Organic Act of Guam. I have some experience in the United States Congress. I served as a lobbyist to a number of different organizations. I worked on the Hill for 5, almost 6 years. I represented and advocated for groups that supported farmers and nurses and educators, groups that promoted national service. I did that in both the House and in the Senate, so I have a great deal of experience there. And while I was working there, many people that I encountered, I was the first person they've ever met from Guam. So in my mind, their experience with me is a reflection on my island. And I really took it upon myself at every opportunity to educate them about Guam, to tell them about our territorial status, to let them know about our island and our unique challenges. But the fact of the matter is, districts, they're only really concerned with their district in Georgia or in Iowa, Nebraska, North Dakota. They might care about their neighbors and the surrounding states. Or maybe if they have a really big industry like coal mining, they care about all the other places where they might have coal mining in the United States. But that's about it. It's very difficult to get other members of Congress to care so much about your particular issue, especially when you're a non-voting delegate. We have very unique challenges, and everybody in this legislature has skin in the game. We are members of this community too. So that's why it's so important that we're the ones that make the decisions, because we're the ones that are going to have to live with those decisions at the end of all of this. One of the ways in which our current delegate and delegates before her have been able to really raise the profile of Guam and get other members in both the House and the Senate to understand what's going on here on Guam is the use of congressional delegations. And so they bring members of Congress out here to Guam and to other territories to really see for themselves. And then they have a much better appreciation, a much better understanding for what it is that's going on here, what our unique challenges are. And in this past term, I believe we've had about 2 different congressional delegations come and meet with us. And never in any of those meetings were these issues brought up. We brought up issues about our natural resources. We brought up issues about the military buildup. But if these issues were so very important, why wasn't that the first thing raised? When we have a face-to-face meeting with other members of Congress. I also just want to point out at the public hearing for these resolutions, members of the public didn't come out in droves. We didn't receive any public testimony in support of these resolutions. Mr. Speaker, I'm rising because I feel that the leaders before us have fought so very hard for our self-governance. We're currently in the midst of a battle for our own self-determination, in proving that the island of Guam, that the people of Guam, were able to conduct our own affairs. We don't want Uncle Sam to micromanage us. We're capable of doing things on our own. And when things don't work out the way we want it to, as many times have happened in this body for me, I'm not going to run to Uncle Sam and try to get somebody else to attempt to solve our problems. Again, I really want to thank the sponsor for continuing to think outside the box, but I also want to caution this body that we don't box ourselves out of solving our own problems. I think we have a lot of challenges on this island, Mr. Speaker. But with all of our challenges, all that is wrong with Guam can be fixed by all that is right with Guam. And for that reason, I oppose this resolution to Tusmasi.
Any other senator wish to be heard on this motion? Any other senator wish to be heard on this motion? If not, oh, Senator Morrison.
Thank you, Mr. Chairman, or thank you, Mr. Speaker. I just want to rise to point out a specific section here in the resolution. Clearly, the author specifically points out one recent tax measure that this body took action on. And it points out the liquid fuels tax. And we know there's been other measures, as he's mentioned, that this body and the administration has put before this body to take action on. Mr. Speaker, I was talking to some university students about this issue not too long ago. And the one thing I made clear to some of these students is if you were intending to become a policymaker or run for office or return to participate and do some work in the legislature, I think you possibly need to go undergo some training in how to not conflict with the Organic Act. Or before you even proceed with any proposal, that it is consistent with the Organic Act. And no disrespect to past legislatures, Mr. Chairman, but obviously even when the recent AG's opinion, it was made it very clear in other opinions that we were undergoing and putting a measure before this body that was not conflicting the Organic Act of Guam. So that was the first recommendation I put before these students, is that making sure that, it should be the other way around, where you're seeing clearly that we are pointing out measures or pointing out laws that have been enacted, and it seems that we're having these debates over these laws that are in place and seeming that coming across that the Organic Act is always seeming to supersede these laws that have been enacted. So I think the message was made clear to these students that, when we proceed, or at least with our office and how we've proceeded with any measures, that we ensure that anything, especially if we're dealing with tax policy, is that it was not conflicting with the Organic Act. So I always want to make that clear to folks that we were moving forward, understanding that we were not conflicting with the law of the land. Mr. Chairman, this is my third term, my last term. I saw the cries of our people, specifically, and they didn't intend to come in here and run and putting measures before the people regarding road projects or road repairs, how to address the highway fund. But we sat through many budget hearings, different directors of DPW, the same message coming down on how that highway fund, regardless if we erase or reassign those obligations, it still wouldn't have the necessary revenue to address a master plan that was adopted over a decade ago by the Camacho administration. And we saw that plan continue to collect dust. And we know, we drive every single day on these roads, we know exactly what's happening out there with the wear and tear of our roads. And understanding clearly, we're going to sit before many budget hearings and see DPW come down, understanding the needs necessary to get these roads going, and we're going to kick the can down the road again. I'm bringing this up, Mr. Speaker, because it's pointed out here clearly in this resolution. And maybe the key to why the author has moved forward to see how this could be incorporated into the Organic Act. And I'm very concerned, Mr. Speaker, sometimes that when this body or future bodies or future legislature attempts to move forward something that we need to address in this community, we undermine the integrity of this body, we undermine the efforts that key folks in our community that work in these agencies are putting before us proposals that we need to put forward. When the director proposed that many times, not just this director, that we just needed to incrementally adjust this liquid fuels tax structure, I watched all of us, and obviously I just didn't want to be that person that didn't at least try. And all I could say is I could put it before the body, debate it, and see if we can get enough votes necessary to help DPW out and address the needs of our community in getting these roads repaired. Fortunately, Mr. Speaker, the will of the body spoke, and I'm grateful that the body spoke and felt that our roads and addressing a master plan before us, and we kind of water it down now. $1 billion master plan is now watered down to basically the top 3 roads in our villages. Well, at least we're starting somewhere. But we had to make some adjustments. And we still are, I believe, the second, if not, the second lowest in the nation with this adjustment. And regardless of this adjustments, as you already see with the fuel prices, I'm not seeing the uproar compared to the liquid fuel tax measure with these recent adjustments out there with our fuel companies. Pointed out before, regardless of any liquid fuel tax adjustment in the future, those prices are going to go up. And I just hope that we cannot continue to undermine or completely put blame on this body for a responsibility that we have to address the needs of our community. And if it has to be done in this manner, unless there is another alternative solution, and so be it, put it before us. But again, just recently in the budget hearing, we had an individual down there, Mr. Speaker, talking about another master plan. to rebuild or revitalize the city of Agatna. I'm very concerned that plan would just collect dust again. But obviously there is not enough resources and we know going forward that this body is going to have to do something to carry out that master plan. I'm not here to point any doubt in the good intentions of the author here that I understand, but I also want to make sure that, you know, what took place wasn't just somebody waking up in this legislature wanting to increase taxes. There's a time where you can only look at proposals coming for this body to help us make a decision, even though it's unpopular, but to address a need in this community. And it went through the process, Mr. Speaker, of a public hearing. We debated it, heard the concerns, made the necessary amendments, we voted on it, it passed, it went through its process. So, Mr. Speaker, I just wanted to point out some of my thoughts, understanding that, you know, it's spelled out here in this resolution, and obviously there has to be some message shared with that why we underwent this whole process. It didn't just happen overnight. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard? If not, you may close. Wait, Vice Speaker? And not to, I've been advised by clerks that we're going to need to stop just after 12 so that they can do whatever they do with Google or YouTube to capture the... Please.
Thank you, Mr. Speaker. I wish that we were here today to debate the actual merits of a proposition that somebody wishes to put before the people, but that's not what this is. In fact, I think in this term that I've been here, there has been no proposition that has been proposed that we could debate to be put before the people. And that's despite the criticism that only 8 people in the legislature of Guam are allowed to act one way or another. It's ironic that we're actually debating a resolution where 8 people in this legislature will be able to tell Congress that the Guam legislature requires further restrictions in order to be fiscally responsible, in order to be responsive to the people of Guam. Obviously, I don't believe that that is correct, and I don't believe that there's not another way for us to act as a legislature. I wish it was also a debate on some mechanism that would allow us to choose our status, or even a debate as to which status to choose, or what our Constitution should look like after we've chosen that status. That's the debate I really look forward to. Should we include a provision for referendum on taxes in our Constitution when we have chosen our status? I look forward very much to the debate, and I believe that many of the points that the author of this resolution makes are valid in that debate. The problem with this resolution for me is that it's taking a matter that one of the few matters that we have been given control of, the people of Guam, the legislature of Guam, the executive branch, and that is our, taxes. And I just think we need to work harder and to deal with what we need to deal with taxes. We need to do what we need to follow the processes that have been put in place to give the public notice, to discuss these things with them, to get their input on them, to listen to them. And we need to, there are just so many things that we could do. And but going to Congress and asking them to do this is to me not one of those things. That's a last resort. That's something, the only thing good about this resolution, that it's not coming from Congress, and that it's actually coming from one of us, and hopefully we can curtail it. That's my hope. Because if it was coming from Congress, it would be added to the list of things that have come to us from Congress, very similar to this, that tell us, how to govern. And then tell us, that they will not allow us full self-governance. For example, there's so many things that have happened in Congress, even recently, that the Guam Legislature has not been able to have an impact on, to stop. For example, when the war claims were going to be paid out of Section 30, the Guam Legislature had no ability to stop that. That was a decision by Congress to take the money that the Guam Legislature had been receiving in Section 30 and to pay war claims out of that money. And that was a significant decrease in revenues for the government of Guam's expenditures that the government, we as a legislature and the entire government of Guam has had to incorporate and address because of the actions of Congress. Same thing with the EITC. They do not reimburse us for EITC, and despite our requests to them and are pointing this out to delegations in resolutions, they've not addressed that. Yet this have a very significant fiscal impact on the people of Guam and their taxes and our ability to pay tax refunds. We've also been very much impacted by the compact impacts and the lack of adequate reimbursement by the federal government. And this is another action that, Congress has taken without recognizing our input or accepting our input, that the amounts that they are reimbursing us for compact impact are not sufficient. They do not adequately match what we actually are using to take care of the United States' obligations to these countries. So when it comes to fiscal matters, I just believe if it's a power that's been given to us by the United States Congress, and we are having issues in here of we can't get enough votes, or we can't get the governors to go our way, I just think we can work harder, Mr. Speaker. And I know that some of you have done this for many more years than I have, and perhaps you just think that's naive of me. But I don't believe so. I want to, and I do believe that, as a previous speaker says, I like that phrase, what's good about the people of Guam will overcome what's bad about the people, and I don't even think it's necessarily bad. I think it's that the government has allowed people to be misinformed, wrongly informed, or totally uninformed. But when they are fully informed, they're not going to stand for it. And so I just feel we just have to continue to do our job, keep them as informed as possible. It's very hard for us to keep informed when it comes to fiscal matters, and I'll be the first to admit that. Even as a senator, it is so difficult for us to get the truth when it comes to fiscal policy. And as we witnessed just recently, we were told all kinds of things in order to get, certain bills passed, and I just think we as a legislature, we need to put a stop to that. We need to be very, very firm when it comes to facts, and that those be all laid out on the table, and so that we can all make informed decisions. And I think the same thing with the people of Guam. And if we are going to give them a proposal, then let's debate that proposal. What is the referendum that you want to put before them? And I'm all for that debate. But I just don't think, again, that this is something that, because, in this moment, it's not going one way or the other, that we should hand it to Congress. We should take care of it ourselves, Mr. Speaker. This is not going to give us greater autonomy. It gives us less autonomy in self-government. And we can, and we have. This law was passed by the Guam Legislature. It's not been repealed, to my knowledge. And we continue to operate by law, Mr. Speaker. And until we get a constitution, I'm all for the debate on whether this should be included in that constitution or not. Thank you, Mr. Speaker.
Thank you very much. Again, at the request of the clerk, I'm going to have to stop at this point so they can capture the 3 hours, otherwise it's lost. Okay, so we'll take a recess until 2 o'clock.